Right now, I want to bring in our legal analyst guest this afternoon. Joining me is criminal defense attorney Vinoo Varghese. Vinoo, great to see you. Thanks so much for coming on the program today. And if we can, let's talk a little bit about, I know you were just listening to the segment that Chanley and I did talking about Lisa Christensen, and you heard her share some of her perspectives about the case. Give us your thoughts on what she shared with the public.
I think the most important thing she said was the impact that it had on some of the people who witnessed this. And that was a major problem for Derek Chauvin. It was a major problem because his lawyer didn't object. I have to tell you, one afternoon, Julie, I was sitting here at my desk. I was about to go on to comment on the case for another network, which shall not be named. Was also providing gavel-to-gavel coverage. So I turned into you and I saw you talking to Chanley, and you brought up the fact that Nelson wasn't objecting and all this cumulative evidence was coming in. And, it really hit me because I was sitting there. I was like, this isn't right. This isn't right. And so when you have all this evidence that wasn't objected to, and I think at the time, the day I was watching, you were talking about the medical testimony, which was certainly cumulative. But it was the impact of these people talking. So, for example, one of the things that really bothered me was that Nelson didn't object when the brother was allowed to testify. And I understand he made an objection pre-trial, and that Minnesota has this bizarre thing called the spark of life thing. But when this witness, he gave gut-wrenching testimony. it was tear-jerking, talking about George Floyd and the impact it had on him and his mother. And it was rough, and he was telling what a good guy George Floyd was. Nelson, at that point, it's my view, the prosecution opened the door to all of that evidence about George Floyd's past, his criminal past, his home invasion of a pregnant woman, and Nelson should have rammed that right back. And really, when he was that really being a good guy when he committed home invasion of a pregnant woman in Texas? Was that honoring your mom? He never did anything like that because, he wasn't up to task as far as I was concerned. And then you have all of these things. And what I commented on that not named other network was that the different things that he did and didn't do throughout the trial. So there was a lot there. And this alternate juror, just hammered home the impact that hearing the effect that it had on witnesses. So some of the witnesses were allowed to testify about the emotional impact it had on them, such as the girl who took the cell phone and how she stayed up at night apologizing, and Nelson didn't object to this. Mm-hmm. So I think there's a claim for ineffective assistance of counsel, amongst other things, that are going to be available for Chauvin upon appeal.
Bingo, Vinoo. I'm so glad you said that. You took the words right out of my mouth, because as I was watching the clip, same thing, we think alike. I know exactly what she's talking about. Many of those bystanders were talking about how they felt upon seeing that horrible incident taking place. And I'm thinking, object to Eric Nelson. He could have done it in such a way where he asks for a sidebar. Those witnesses wouldn't have known, he was advocating, for that testimony to be limited, and anything that did come out already to be stricken and disregarded. But yeah, it's irrelevant. It's totally irrelevant. And the state got away with a lot here. They really did. And you're right. Much of it was because I felt like he was asleep at the wheel at times that were so critical. So thank you for mentioning all of that, because you're right. In addition to a potential appeal, there's also a potential ineffective assistance claim that very well may be raised here. And I felt for him. I could tell he was exhausted. It's not easy, but you've got to object. Ugh. Okay, on to something else. I want to get your take on something else from Lisa Christensen. Here's a clip. This is where she's talking about how she didn't realize this case was as big of a deal as it is until after the fact. So let me play it for you now.
No, not until we were dismissed and Judge Cahill said that, you're free to turn on the news and talk to whoever you want to, and, you could go out here and have a press conference if you want to. And no, I wasn't aware.
That's the one thing, Vinoo, I'm kind of like, really? You weren't aware it was as big of a deal? I mean, because they were traveling back and forth to the courthouse, seeing the interest. I mean, if they weren't turning on their television sets, as they were cautioned not to, they were certainly seeing all of the protesters gathered around day after day. Give me your take on it, please.
It's a very strange comment. I really don't know what to say.
Yeah.
I guess she must have been the only person in America who didn't think that way, and she's sitting on the jury. So I don't know what to make of that. I will take her at her word at the moment. But I think that this brings up another issue, which is the fact that they were told not to watch the news, but they weren't shut down on their social media. So with all the other stuff going on at the time, with the Daunte Wright shooting, the protesters, Congressman Waters. Now, that's one thing that Nelson did raise before the judge, and the judge had some comments about Waters and basically keeping her mouth shut. But at that point, what Nelson should have done is ask the judge to poll the jurors and say to them, hey, all this stuff's going on. Is this having an impact on you? Because some of them said or at least it seems a lot of them said during jury selection, that they were concerned about the ramifications. And my biggest concern for these jurors was that could they, if they found reasonable doubt, and I do, there was definitely stuff that Nelson did bring out. If they did find reasonable doubt, would they have the courage to vote that way? Knowing that they can go home and say to their friends and their family that they acquitted Derek Chauvin. I didn't think so. And particularly when all this stuff was going on, maybe that's when this alternate juror realized it might have been a big deal. Mm-hmm. But when all this stuff was going on, the judge should have polled these jurors, but I know why he didn't, because he didn't want the answer to that potential question. And certainly that would ruin and have a mistrial on the very first trial that was televised in Minnesota history, from my understanding.
It was, you're right.
I mean, so he wasn't going to allow a mistrial under any circumstance, because he was waiting for the handcuffs to fall on Chauvin and be carried away in that classic Hollywood moment.
I'm with everything you're saying. Vinoo Varghese, love having you on the program. You're going to stay with us kindly. We want you to stay with us at home. When we come back, we'll talk about the case against Thomas Lane. All right, I want to bring back in our legal analyst guest this hour from New York City. Criminal defense attorney Vinoo Varghese is still with us. Okay, Vinoo, I want to pick your brain, really tap into your criminal defense experience here. Looking at these three remaining defendants, particularly Thomas Lane, it seems like of the three of them, he has the most viable defense in this case. Give me your thoughts. How might you defend it if you were asked to be part of his defense team?
Well, there was a lot that he said. I'm just going to just talk about something you just mentioned about having the most viable defense. I mean, the argument can be made that Officer Tao had the most viable defense. He was the only one who wasn't touching George Floyd. I mean, Lane and King had Kung had their knees on him in the back. And interestingly enough, the prosecution's witness, the pulmonologist that the previous alternate juror was talking about and had the impact it had on her, that witness actually gave, in the testimony, what I thought was the most strong point for the defense in terms of reasonable doubt, that there was other factors that led to George Floyd's death. And while he disputed the drugs and everything else, he said that being in the prone position, handcuffs, other factors. Well, then there were other things going on. You had the two officers with their knees on it. Now, in terms of defending them, I think, and it can cut both ways. But what they want to focus on, and I think all three of them will probably be in unison on this, is that Derek Chauvin is the one who killed George Floyd. Okay, it's on him, and I'm not sure how much they want to stray from that, because aiding and abetting, especially when this young man says, "Hey, he doesn't have a pulse, should we turn him over?" He is taking orders from his superior, and I do think that with these prosecutions, to charge these guys, I think was excessive. So you have particularly because they're rookies, but. I think that it's gonna be tough for the state here, and they're gonna sit there and point to the chair and say, "Hey, there's somebody not here. You know what happened to him. He's guilty. We're not.
I hear you, Vinoo. Let me play for you. I want to play for you a little clip from an interview that I did with Harvard Law professor emeritus Alan Dershowitz. He came on the show both Tuesday and Wednesday with us, so before we even knew of the verdict announcement, and then again on Wednesday. And we had a really good discussion about how this jury in the Chauvin case was exposed to so much because they weren't sequestered. And I want to play for you what Alan Dershowitz said, what he sees as a solution, and then get your thoughts on the other side on how we can improve in America. Let's watch.
We're willing to believe that everybody in the world knew that there was going to be violence if there was an acquittal or a verdict of manslaughter, except the 12 jurors who weren't sequestered. Now that just defies credibility. They were not sequestered. They could watch anything they wanted other than the news. Who knows? Maybe they didn't even listen to the judge's instruction on that. But they could watch YouTube. They could go on the internet. They could listen to their friends. They could listen to podcasts. They can listen to the radio. They can listen to court TV.
All right, Vinoo, what do you think about what the professor said?
I think Dershowitz is right, and we just talked about this a couple of minutes ago. They weren't prohibited from looking at other stuff. I mean, this was the trial of the 21st century, and this jury should have been sequestered. This jury should have been protected from all the stuff that was going on outside, and they weren't. And I don't see any reasonable way that it would not have had a negative influence on them.
I'm with you there. Vinoo Varghese, great to have you on the show today. You're going to stay put. When we come back after the break, we're going to get up close and personal with world